156. You do not need to post your appearances on the
Can't hear.
record. Can you hear me?
Very little.
Can anyone else? Is anyone else have a problem hearing me?
Yep, the volume was low for a minute, Your Honor, but I can hear you now.
Loud and clear.
All right, thank you. All right. In this particular case, I had a breakout room with the attorneys to try to discuss this case. Last time you were here, Mr. Massey, I adjourned the matter for me to have an opportunity to look at what I thought was supposed to be video, but when I went back to review my notes again, it wasn't the video. It was the case law that I was actually taking a look at. I did review the case law that was cited by both the prosecution as well as the defense in this case. And the case is People versus Wood, 450 Mich 399 is the case that I initially started looking at. The issue that was raised mainly at the time of the hearing was whether or not you had physical control of the vehicle versus whether you were operating the vehicle at the time. As I look back at the case law, and one of my concerns was obviously at that time, and it still is, what rights the police have to actually investigate when someone's pulled over to the side of the road. And the police in this particular case got phone calls regarding what they believed to be a domestic violence incident. The testimony at the time of the hearing showed that you were pulled over because the woman that was in the vehicle at the time with you needed to use the bathroom, and therefore you pulled over to allow her to use the bathroom. The issue is whether or not the police have the right to actually arrest you at that time after you actually admitted that you were driving and that they suspected that there was alcohol usage. The case that I have cited and that came up for me as I was doing the review of the case law is a case called People versus Keskamaki. It is case number 446 Mich 240, which essentially says that there is an accident exception that facilitates drunken driver safety by eliminating any delay in securing prompt medical attention. So people can't just be questioned on the side of the road unless they're actually operating the motor vehicle. In this particular case, you were out of the vehicle and not operating, which brought up all these particular issues. The court finds that the People versus Keskamaki is controlling in this particular case, in that there was no accident, so therefore they would not necessarily have the right to arrest you. However, the exception, the issue that is sort of different and distinct in this particular case is that you admitted to them that you had been driving while there was drinking. So the issue becomes whether that admission is admissible or not at this point. So that is the issue that we have. And I have asked both counsel to respond to that particular issue. I'll start with Mr. Vincent.
Your Honor, it's clear that the police were originally sent there. They believed some type of assault was going on. One deputy arrived, and I believe the report indicates he separated two parties. One or two, I think one state trooper showed up, then a second state trooper showed up, and I believe there's one other deputy arrives, but there's several police officers on the scene. He clearly was being asked questions about the assault, clearly was being asked to ask questions about drinking and driving. He was in custody. There's no place for him to go. Police aren't going to let him leave. I mean, to me, it's just obvious. You're not going to walk away while the police are talking to you when several police are there. And they never told him, you don't have to talk with us, but we'd like to ask you a few questions. I think the case, Your Honor, cited that they have no right to do this, to question him unless there was an accident. There was no accident. He had no right to leave. And whatever he said, it was without Miranda warning. And a Miranda should have been given to him. They're going to start asking questions. This is more than a simple stop at the side of the road after a police officer follows him for some distance. This is a whole different case. entirely different. There was nobody saw him driving. Nobody made a report of him driving. There was no report saying there's a bad driver driving on I-94. The only report they had was an assault. Thank you, Your Honor.
Thank you. Ms. Woods, first of all, do you acknowledge that he was not read Miranda, or do you believe that he was?
Judge, I don't know. I mean, that was never an issue that we talked about when we had this hearing. The officer was never asked any of those questions as to whether he was free to leave. I know that officers are allowed to ask questions. They're allowed to do an investigation. There was the first officer that pulled him over. I don't know if he told that very first officer that he was driving that vehicle. Those are things I don't know. Those are things that we never got into at the hearing as to whether he was free to leave. The defendant never testified. So he never got up there to say, hey, I felt like I wasn't free to leave. Just because defense counsel's making that argument was never put into evidence. None of this stuff that we're ruling on right now was ever brought up at the hearing. These are things that were brought up after the hearing. Defense counsel, made his arguments. He should have brought up these arguments at the hearing, and that's something that he never did. And now we're coming to the day of the ruling, and all of these new issues are being brought to light. I mean, these are things that should have been litigated at the time of the hearing when defense counsel had the opportunity to do that, and he failed to do that. And he never even brought up any of these things. They're brought up by you, Judge. So to me, none of these issues were litigated at that hearing.
Well, the way it works right now is that I'm ruling that this was not an accident, so therefore the police did not have the opportunity or the right to actually arrest him based on that alone. So are you indicating that you want to establish that it was not? I'm not sure what you're saying you want to do.
Judge,
Because
you're talking about whether he felt he was in custody and that the police had a right to question him. These are issues that were never, I don't know the timing of those. They were never brought up at the hearing. And you're going to make a ruling on that. And to me, I just feel like these are issues that were never litigated.
So therefore, what?
I'm confused as to what you mean, therefore.
Therefore, what happens? What are you suggesting is supposed to happen next? That's what I mean.
Well, I mean, are you saying that we're now going to have another evidentiary hearing on whether?
I'm asking you what you're saying.
I mean, if you're going to rule that if you're ruling that that this is a Miranda issue, I think that we should again have another evidentiary hearing, but on that issue, because that issue was never litigated.
Well, I'm saying that in essence, the police did not have a right to arrest him because there was no accident involved in this particular case. So if you have an argument as to something past that, that's your argument.
Well, he wasn't arrested on the accident because he was arrested following an investigation into drinking and driving. That's why he was arrested.
And Mr. Vincent is therefore saying that the questioning that occurred based on that was in violation of Miranda.
And I'm saying that was never litigated. That issue was never litigated at that hearing.
I heard you say that over and over again. So therefore you're asking for a Miranda hearing? Or is he?
We're gonna say is suppress this case because you're ruling that we violated the defendant's Miranda rights, then I would ask for a hearing. Because I think that's fair.
Mr. Vincent?
Well, Your Honor, there was a hearing. It's not my job to make the prosecutor's case. The Kaminsky case, and I'm going to spell it out just so we have it. Keskimaki states what the court says it states. They started questioning him. Clearly, they thought there was an assault going on, and it morphed into a drunk driving investigation. Somewhere along the line, they should have read him as Miranda. If the prosecutor wants to make that the key point of her evidence, then it's her duty to establish the foundation for admission of a defendant's statement. And that was never done. And I agree with the court, and I don't know how you spell it, Kezemaki. I agree with the court on that. And I also give this an unusual case.
Well, she's requesting a Miranda hearing to establish that he was free to leave, I suppose. Because if he wasn't free to leave, then it would be a violation of Miranda. That's what we boil down to. So I guess we'll need another hearing date, and it will need to be on Zoom. So nobody needs to come in here.
The record should reflect, I'm not asking for a hearing. I think the matter is clear. And the prosecutor's trying to say, I should have done this, I should have done that. The fact of the matter is, if she wanted to introduce the evidence, she has to lay a foundation. And she
Well,
didn't.
it would be your motion to suppress. You want to suppress his statements. That's what you want to do next, right? Because
Yes.
so that issue does need to be addressed. I agree with her on that part.
I guess we just need a date.
Okay. Which I'm looking for right now. The first Friday in February. Is that? Or were you looking at something else? What is the date? Okay. Does February 7th work?
Good morning, Your Honor. February 7th works for our office. Thank you.
The court knows they won't allow me to schedule anything.
I'm fully aware. Can we do this at 10 a.m. on February 7th?
Tell the judge.
That works for our office, Your Honor. Thank you.
I heard you. I'm asking Ms. Woods now. She hasn't responded.
I'd leave the time up to the court.
February 7th at 10 a.m. it is.
Then I gotta dictate something. You're right after this. I killed myself working out Sunday. Overdid it. Okay, it's gonna be your job.
I will see everybody then. The only issue that we're going to be addressing is whether or not the defendant was free to leave and whether there was any violation of the defendant's right to have Miranda read to him at that time.